this regular meeting of the City Plan Commission to order. It is 4:50 on Tuesday, August 18th. We'll start with a roll call.
Noel Sampson. Dave Caldwell.
Lindsay Petnelly. Rachel Dawson.
Shiljan Mandrakar, DPD staff.
Bob Azar, DPD staff.
Megan DeSanto, legal counsel.
And I am Michael Gazdaco, Chair. Next up, we will roll to the approval of the minutes from the July 28th, 2026 meeting. Hopefully you've all received them and had a chance to peruse them. I didn't see any edits that were necessary. If you do, please speak now, and if not, we'd entertain a motion to approve the minutes as drafted.
Motion to approve.
I'll second.
Okay. All in favor of approving the minutes as drafted, say aye.
Aye.
Any opposed? Any abstentions? The minutes pass. Director's report. Mr. Azar.
I really don't have anything for you this month.
Well, it's the end of summer. Let's kick it into gear then. Before we go into the first agenda item, we should, point of clarification, there was an agenda circulated prior to the finalized agenda, which had a major land development project for 31 Dyke Street. That has been removed from this agenda. So if anyone is here for that agenda item, we are not hearing that agenda item this afternoon. With that, we will go right into the first agenda item on the current agenda, which is case number 26-046 UDR 14 Cargill Street. Now this item, do you want to explain?
Yeah, very simply, the applicant has withdrawn. This was one you'll recall that came before you as a unified development review. There was actually a 2-2 vote on the zoning variance, which our attorney has opined means that the zoning variance failed. It was a denial. And so the applicant has now withdrawn. They are revising their plan, and they should be back before us in the coming months.
Okay, thank you very much. Then we'll go right into agenda item number 2, which is case number 26-047 MIL. It's 203 Douglas Ave.
So this is a request simply to continue this item to the October 20th meeting. This is at the applicant's request. This was originally going to be on this docket. My understanding is that they're still working out some of the details on the plan, so they simply want to be heard in October.
And this is the one we continued to this date last month.
That's correct.
All right. I care to make a motion to continue this to the October 20th meeting.
Make a motion to continue to the October 20th meeting.
A second?
Brennan.
All right. We'll just do a voice vote for this. All in favor of continuing to the October 20th meeting, say aye. Aye. Any opposed? Any abstentions? The ayes have it. All right. Next up is a request for extension, case number 23-065 MI 125 Tobey Street.
Okay, this one was approved a couple of years ago, and last August, you granted an extension for a year. They had originally asked for 2 years. You granted an extension for a year, and this approval is set to expire on September 16th, 2026. This is a minor land development project. It's a multifamily in the R4 zone, and this was approved at a time when we had not made the major updates to the zoning ordinance that we did following the adoption of the comprehensive plan. This was at a time when we had a practice of spot zoning R4 for multifamily. And this is a project that fell under that. Since then, the zoning, the underlying zoning of this lot, of all the lots around this lot, have been changed to R4. And therefore, the project that was originally presented and approved, based on my analysis, is pretty close to something that could be approved under the current zoning. There might be a couple of issues with setbacks, but really not that much. The density would fit within the current zoning. So, you know, even if this project if the approval did expire, they would be able to come in with a project very similar to what was approved, and it would be a simple staff approval as a minor land development project. Last time they came before you, one of the arguments was that they were waiting on clarity from the city about tax treatment, either tax stabilization or the 8% tax treatment. And so I don't know really what's changed since then, but the applicant's representatives are here and they may be able to further explain.
As I recall, my memory doesn't always bode well, but that they asked for 2, we said 1 because they kept saying they were really close to finalizing all of these things, right?
Yeah, they came in with a few projects that were requesting, I think there were 3 of them that they were requesting all at the same time. And that was among their arguments, that they were close.
Okay. Well, the applicant's here. Let's hear from them.
Yeah.
Is the mic on? All right, you got it.
Good afternoon. My
Speak right into it.
name is Zachary Bordone. I don't care for the
Lily Rich is also representative of that.
So we're here today to request another 1-year extension. Part of the reason is there have been some new sort of funding liabilities for affordable housing, which that is the goal with this project, is to provide affordable housing. In particular, there is a grant program with EOH, where they're in the midst of the second round of funding. They had $20 million worth of funding for this year. The first round, they awarded $7.5 million, the $12.5 million left. We were hopeful to submit and qualify for this round of funding, but there were answers submitted to from questions last Friday, just simply 4 or 5 days ago, that sort of complicated things a little bit. And one of the issues is on this project is 14 units. So to qualify for this program, it's focused on home ownership, which does include condos. And they would be deed restricted to help provide affordable housing units. And one of the issues is once this project is ready for to go on the market, there's going to be 14 deed restricted condo units with not one-to-one parking. That is a difficult thing for the market to absorb. So one of the hopes was to qualify for this program, but still be able to rent out any units that don't sell immediately. But we have just gotten answers from EOH on Friday that says that the program is not does not allow for that. So what we've done is we have already spoken to the governor to try to get the next round of funding, have some sort of changes to it to allow these sort of scenarios to qualify for it. Like I said, we're in the second round of funding. There's $25 million slated for the next calendar year. As of right now, for the first 2 rounds of funding, it seems to be every 6 months that this seems to be happening. And so the applicant is very interested and focused on providing, the affordable housing, the deed restricted units. And so we're very hopeful and confident that, we will be able to get the EOH and the Secretary of Housing to amend the program to allow, renting the units while you're waiting for, the condo units to sell, because it has to be, single family type unit to qualify for the program. So as of right now, for the current round of funding, the deadline is to apply is at the beginning of September. So based upon how it has been allocated so far, we would expect, another 6 months from September to be when, they could apply for the next round of funding that has already been, been slated for the next month.
And the applicant hasn't moved the plans forward enough to file final plan because
It's trying to figure out the financial viability of the project, given that it's going to be an affordable housing project. It does need to have some sort of grant funding or subsidy to help it become a viable project, and the risk of having an unknown amount of those 14 units be on the market for an unknown amount of time. It does make it a little difficult, a little difficult for them to be moving forward until they know for sure, kind of the funding sources that they have to make sure that that will not be an overall problem.
I'm not saying to build it, just to move the drawings along a little bit more and spend all the money that they're spending on these applications on the project and finalize it, so you don't have to come back to us for a continuance that we said we didn't want to give more than a year last time.
Right. I don't believe that anything has been submitted for the final plan approval, but we would just ask for another year to have that time to do that.
And you realize that there's really not much difference now that the zones have changed and the zoning has changed. There's not really much of a compelling reason to give you this, because there's not much difference between what you submitted previously in the old zoning to what you could submit now. Maybe some setbacks change a little bit. Unit count would stay pretty much the same.
I can't say for sure, but I would imagine it would be not only building size wise, dimension wise would be different, but this would most likely be 14 market rate units that would go on. That would be, and they'd be rental units, probably not even condos, so that it would be eliminating affordable, new home ownership opportunities.
Why would that be if it was the same basic building?
Well, the goal right now is to go forward with the affordable housing. And even if that were to happen, if this were to expire and, we were to provide that, then I would imagine, there'd probably be requests for, dimensional adjustments as well. So you can get another story again, some, increased density in there as well. And any other sort of adjustments that would be allowed.
Speaking for myself, this board has been very open suggestions of extra units and higher density. To have something sketched up and drawn out, I don't think that's much to ask, whether it's some percentage market rate, some percentage affordable, rental for sale. Is it fair to ask that we haven't seen much progress here? Just saying that
We haven't seen any.
We'd like to see something. I'd like to see something. Well,
Well,
open to,
the biggest issue I have is that this was one of those applications that your firm put forward, or your previous firm put forward before all of the zoning changes happened. The comp plan and the zoning have taken effect now, and that's what we want going forward. So to continue to move this forward based on relief we gave previously doesn't seem to make sense if the applicant isn't serious about building it, when you could build something based on the way we moved what we want to see coming in as applications forward today. And it wouldn't be much of a difference than what you already had.
I think Bob was right. There would be, some differences to the setback, and based upon how the building is right now, it would require us to come here for dimensional relief.
Or you could build a building that complies.
Right. Everything's been, kind of fine tuned to be, compliant. It was fine tuned back then to be compliant with how it was. And
But if it was fine tuned, how could, if you had enough information to fine tune all the details, you would have enough information to submit your final plan approval. And you wouldn't have to come back to us for a request. And final plan doesn't expire.
Right.
So I'm curious as to why that hasn't happened, because that's what we said last year when you came before us, is we wanted you to do this. Move this forward, because I said I wasn't interested in giving you another year for this project. Specifically because of all the changes that we've taken the time to make in the comprehensive plan and the zoning code.
I would just ask for, kind of good graces to just get one more, year extension on this one. I believe, if this qualifies for the next round of funding for the EOH homeownership program, I think that will help this move across the finish line. Because like I said, right now they have 25 million slated for the next year, and which is more than they've afforded for this year. So I think it's my understanding that's kind of the final piece of the puzzle that will get everything moving based upon the design that currently exists.
So you said you're submitting in September?
It'll have to be for the next round of funding because, like I said, there wasn't too much guidance on if you could rent out units while you're waiting for the condos to sell. But some questions were submitted, the answers were provided. I believe it was this past Friday, saying that as it stands right now, that's not allowed. So kind of the risk with the absorption of the units into the market has prompted us to reach out to the governor to try and have the next round of funding be, I guess, tailored or edited to allow these sort of scenarios that take into account the risk of the absorption of the units.
We've already given you 2 or 3 months. I mean, I think that's more than generous, probably more than, I mean, we're talking about an application from 2023. 2 to 3 months would give you time to finalize your plans and file a final plan approval, which is all you'd have to do to vest this forever and continue to move down the path of your funding goals or whatever that target ends up being this time next year when you come back.
Right.
Because that's what you said last time. It was 2 different funding goals then. So I just don't see a compelling reason to give you any more than that, because I think you can file the final plan approval, the final plan administratively. It's not a heavy lift.
I would ask if you're not going to grant a year, then we would ask for 6 months.
All right. I propose 3 then. But
I would agree.
yeah, I think 3 months is more than sufficient time to finalize all these details. Your plan expires in September. That would give you till almost the end of the year. I think that's more than enough time. Commissioners, I've been hogging the microphone on this one because I have some thoughts on it, but any questions you have for the applicant? I don't want to be the only one.
It sounds like it's another parking issue. Would it come back to us at any point, or it would just sail right through?
No,
Okay.
this is if we request an extension, their approvals are extended.
Oh, okay.
And all they have to do to vest these approvals for forever
Mhm.
is to record final plan.
And were there drawings submitted initially?
Oh, there were in 2023.
Yeah, they have preliminary plan for this land development project approved. They have to actually do work on it.
Yeah.
This thing has been sitting without anything being done on it for a couple of years now. All they need to do, well, I'm not, if I sound frustrated, it's not at you. It's at the fact that they have an approval. There is a way forward to get to final plan. They simply need to focus on that and put some resources towards it. And if they did that, they would have had final approval a long time ago. But they seem to want to make sure that they get some kind of funding stream from the state or some kind of tax stabilization or tax treatment from the city until this is absolutely solid before they invest one more dollar in this.
Hoping that money for affordable units could also be applied towards market rate units.
Perhaps.
3 months sounds pretty motivating.
I would personally, if it were up to me, not allow an extension, because I think the purpose of the extension is for more work to be done. I'm not asking for a lot of work to be done here, but we are a very accommodating board to those who build housing, who want housing built. I would support a 3-month extension, grudgingly, but I think, you know, my opinion, that this should have moved. We should have seen a little more. That's the point. Unless I'm mistaken. That's not a point, but that's my opinion.
And 3 months would give time to do whatever they need to do to
More than-
finalize the plan. Well. This one, we don't have to hear any public comment on, so if there were a motion, we could just entertain one. This is our discretion.
I will make a motion that a 3-month extension be granted.
Yeah, we have a motion for a 3-month extension.
Somewhat reluctantly.
Okay, we have a second. We'll go around. Noel?
Aye.
Dave?
Aye.
Lindsay?
Aye.
Rachel?
Aye.
And I vote aye. Good luck.
I get
It will say get to work.
Yeah, because I don't expect that we will approve another extension. All right, next item is referral number 3622, rezoning of 21 and 25 Douglas Avenue. The petitioner is 21 Douglas LLC. We have a representative from, is it you, Mr. Attorney Bordon? Okay. You just acted like you were standing up, but you were just standing up and sitting back down. All right, who's introducing this from our team? Is it you, Choyan, or is it?
Yeah, sure. I can do a quick introduction. Commissioners, these are 2 lots that are currently zoned R4. One is occupied by an office building, and the second is vacant and used as a principal use parking lot. And the applicant is requesting a rezoning to C2 so that the zoning may align with the underlying uses, and this applicant can elaborate from there.
Yes, so as Brian, but there's a request to go from R4 to C2, and right now, on the lots, one is a parking lot, which is used for the office building, which is occupied by 2 law offices, a criminal defense firm and a personal injury firm. In total, between the 2, there are 12 employees, and most days, for most of the day, all 12 are there. In addition to the 12 employees, they have clients coming in and out throughout the day for various reasons for various time frames. So a little counterintuitive to how we normally proceed with things, but with regards to asking to allow this zone change to then get the parking lot into compliance via special use permit, but it is necessary here. This part of Douglas Ave doesn't have great on-street parking options. Both on Douglas Ave and the side and rear street. I can speak from personal experience on that. But getting this rezoned to C2 will make that office building be just deemed a legally permitted use. I believe that is a grandfathered non-conforming use, so it would get rid of that, make it legal conforming. There's a chance of that. And then again, the parking lot. Right now, it'd be getting the rezone and submitting for a special use permit to keep that parking lot there. And as part of the zone change petition, we have proposed to we have submitted a tentative landscape plan that we intend to go through for that lot, which will decrease the impervious surface of pavement on the lot and increase the green space on it and put, a couple trees, some landscaping along Douglas Ave. And I know in the staff report, it was recommended to make sure that the lot of the office building also comply with the canopy and landscape coverage requirements, and we have no problem with that. But this owner has, kind of helped contribute a little bit to the, housing crisis. What you see on the screen right there, lot 134 and 135, I believe, they were purchased in conjunction with the two that they still own. And instead of, keeping them vacant, they did, I believe it was a year or two after purchase, sold them to developers, and now we have two families, right next door. But this is a very interesting area of Douglas Ave. It's right at the beginning, and to the side there's some residential units. Across the street there is a synagogue, and right behind them there are a plethora of different auto body and auto body related businesses. And this is also right next to where 146 starts to merge onto 95 and the state office exit. So and then if you go a little further down Douglas Ave there, there's a cleaner in a mixed-use building there, and then you get to ladder 133, the Taco Bell, and the whole shopping plaza over there. So not only this corner, but this area of Douglas Ave, it does present a very diverse set of uses in the area. And in addition, we submitted yesterday, I'm not sure if it got to the commission, but a letter of support from the local state rep on the zone change protection plan.
Yes, yeah, we received that.
Wonderful.
My first question in looking at the materials to prepare for today's meeting is, I look at the zoning map, and I'm wondering why not RP instead of C2.
I don't believe that principal use parking is allowed in an RP, so our goal is to get both lots into being deemed compliant uses.
You could merge the lots if you rezone them both the RP instead of rezoning them off both the C2.
I believe if that were to happen, it would be a little detrimental to like making sure that parking for the employees and the clients are provided on the lot, because whether it would be R4 or RP, it'd be subject to the impervious requirements. And lot 518, it is currently grandfathered in as 100% paved. I don't think it would be possible to have sufficient parking for the employees and the clients if we had to have both lots into full conformance with the impervious requirements.
Didn't you just say you were going to come in conformance with the canopy coverage on lot 518?
Yes, lot 518 currently has one tree in front of it on the street. So where this second one would go, kind of to be determined. At this point, we're thinking, if you're looking at it from Douglas Ave, top right corner, seems the most logical option, but getting in compliance with the impervious.
So you just,
if I said
no landscaping or nothing?
Landscaping, yeah, would be compliant with that as well.
Okay.
And again, like I said, I just want to reiterate that the goal is to get the uses into conformance, as right now they are technically non-permitted uses on the lot,
Right.
on both lots.
Mr. Chair. If I may, so just a little bit of context here. I believe that when sometime after or around the same time that these lots were developed, this lot was paved. And my understanding is that there's a violation for paving here.
Apologies, there is currently a violation for that paving.
So it's not grandfathered like you stated?
Well, no,
Not the parking lot. No.
To his-
The use
yeah.
of lot 518 is grandfathered.
Okay.
Lot 88 is the one that is currently in violation for having paved it.
Yeah.
If my client was unaware that that was a violation, I believe upon purchase, there was a little bit of, asphalt going into lot 88. It was mostly dirt. It's it's where, people were parking, when they were looking at the property, and then afterwards. So the paving, we recognize and understand it was not permitted. 100% on that. And, like I said, the goal is to get both lots into conformance with their uses.
So the attorney's correct that if this were to be rezoned to RP, residential professional, we're much stricter about impervious surface in residential zones versus commercial. So in order to get the amount of impervious surface that they're looking for to accommodate the parking, C2 would do that. They have shown kind of a conceptual scheme for landscaping for this lot. What we are saying is that they should give us a landscaping scheme for the entirety of the project. I don't understand why they wouldn't just merge these lots together if they were C2. That way they could avoid the special use permit for lot 88, because if it's merged, it becomes accessory parking. That would seem to be the easiest way to go. Then they don't have to go to the zoning board after the fact and get a special use permit. And when it comes to landscaping, I think it's important to think about this as an entire site. What's happening here, especially along North Davis Street, there are a couple of parking spaces that have been striped adjacent to this building. Theoretically, you could get 2 cars in here if they both come through the curb cutoff of North Davis Street, as long as one comes first and the other one comes after, and the second one has to wait until the first one has to wait until the second one leaves before it can go. But it would seem to me that because of the way this is all paved, what's supposed to be a sidewalk is asphalt. There's no delineation between the sidewalk and the parking area. I would guess that people are jumping the curb to get into one or both of these spaces. That's not ideal. There's also another curb cut off the back here. There's more asphalt. So I really think that there should be a comprehensive plan for landscaping and parking for this whole site that wouldn't involve people jumping the curb to get in, that would have the proper amount of tree canopy and at least a modicum of stormwater management on the site. I don't think that's too much to ask. So that's why our recommendation is that both lots be brought into conformance with the tree and landscaping requirements of the zoning ordinance. And then again, as we said, as I said, merging lots is our preferred approach here, but if not, then they would have to seek a special use permit for lot 88.
Why is it the desire to request a special use permit instead of merging lots?
I think it would be for lot 88 is its own lot right now. So I think for any potential resale option in the future, it would make it easier, because obviously if they merge and then they would have to unmerge, and then even if it's C2, to get that unmerger approved, we'd still have to seek a special use permit, assuming, the zoning ordinance doesn't get updated whenever that happens years down the line.
Right, but then we're rezoning 2 separate C2 uses that could be a lot of different things that aren't present today. That's why I'm asking is, I think RP is better for the area. I do agree you're gonna get less parking. But if we're keeping these 2 separate parcels in C2, you're gonna use this as a special use permit, and maybe you'll sell it off in a while, and then it's a buildable C2 lot. where a lot of different things can go that aren't as conducive to being adjacent to residential use.
Right.
Just my concern. Commissioners, do you have questions for the applicant before we hear staff report and open it up to public comment? Okay. Let's do a staff report.
Sure, thanks, Mr. Chair, and when we look at conformance with the comprehensive plan, we see that the future land use map, which we say is not intended to be parcel specific, shows that this is an area with a lot of divergent land uses in proximity, and given the diversity of these uses, we do find that rezoning the subject lots to allow for an office and parking lot would conform to the intent of the plan. And we do feel that given the legal use of the building as an office, it would be appropriate to rezone to C2. And as noted, there is no indication that the principal use parking lot was legally established. So, and as we've also said, the applicant is required to obtain a special use permit or merge both lots. And we do find that the change would be consistent with section 101 of the zoning ordinance, as it would allow for a range of uses at an intensity that's appropriate with neighborhood's character. So based on that, we would recommend that you make a positive recommendation to the city council, subject to these conditions, that both lots be brought into conformance with the tree and landscaping requirements of the zoning ordinance. And the parking lot shall be legalized either through a special use permit or by merging both lots.
Okay, thank you. This is a public hearing, so we will open this up for public comment now. If you are joining us in the physical room and would like to speak on this agenda item, please stand up or come forward. If you're joining us in the virtual room, please raise your virtual hand or press *9 if you're calling in.
We didn't have anybody signed up and there's nobody online looking to speak.
Okay. We will close the public comment portion of this agenda item at this time. My only concern is the potential future C2 uses in the residential area. I mean, it is a heavily trafficked area. There's commercial use, so it's not like a stretch. It makes sense, but I would have preferred RP, but I understand that that would limit the parking. I guess I'm fine with it. Again, I prefer the lots merged and not a special use permit. But
Did we ever give the variance for RP, like, give a little to get that?
this is a recommendation to the city
Right.
council.
Yeah,
I'm just curious.
but if they, yeah, I mean, you know, if this were a variance request, say, just let's play this out. If the lots were zoned RP, let's say the lots were zoned RP and they were merged, there would be pretty significant constraints on impervious surface in the RP zone. Bear with me just a sec. So maximum impervious surface coverage for the entirety of the lots, if they were zoned RP and merged, would be 65%. Principal use parking lots in residential zones, which principal use parking lot would not be a permitted use in the RP zone. So they'd be limited to 65% of the entire lot that could be impervious. That includes the footprint of the structure plus all the pavement. So that would, and then there are also constraints on how much of the front yard and how much of the rear yard can be impervious. I think they'd have a hard time complying based on what they're doing today, based on this being a law office. I will acknowledge what the attorney said, which is that there's not a lot of on-street parking along Douglas Avenue and the side streets. So I think C2 gives them a lot more ability to have a commercial operation like this, to have the kind of maybe not quite the amount of paving that they have today, but to have more paving than would be allowed under the residential zone.
And the intent is to build a bigger office?
I think the intent is to continue the use as it is today and to legalize something that is currently under violation.
Is it possible that they don't get the special use permit when they apply?
So the special use permit basically says that you have to abide by the regulations for parking lots, which are, appropriate stall and aisle dimensions and landscaping. So they'd have to come into conformance with landscaping in order to get that special use permit. That would be just on the one lot. Now, Attorney Bordoni said something that I'm not sure I agree with. He said that the pavement on the lot with the building on it, lot 518, is grandfathered. I disagree with that. I don't think there's such a thing as grandfathered pavement like this in a residential zone. There's not, as far as I know, a violation for this, but I would not concede that it's grandfathered. The use may be grandfathered. I don't know that the pavement is grandfathered.
So we can make a recommendation that the landscaping plan includes both.
That's our recommendation. Yeah.
And then any safety concerns with the two spots next to Davis, where those would remain.
I think they're going to have to rethink this parking scheme here. I don't know that. I mean, our landscaping regulations say that there's supposed to be a 5-foot landscape strip between the public right-of-way, where the public right-of-way ends, and any parking. This parking is right up against that property line, as is this parking here. There should be a landscaping strip for everywhere where there's not a curb cut on this lot.
It says 17.75, is that the sidewalk just peters out, or?
This is a curb cut right here, and then this is, you can see the curb, and you can see the property line. This is sidewalk. It just happens to be all asphalt, presumably because whoever paved this in asphalt continued to pave right up to the curb in asphalt. What was the condition of the sidewalk before that? I have no idea. I mean,
Yeah, I mean, I'm not against this in theory. I think we should probably push this forward to the city council, but I don't have as much empathy for the applicant saying that they would lose parking that they illegally installed on a residential lot so it's just not something that like pulls at my heartstrings. Like, yes, the 518 is an existing use, has been there, but then you guys paved the residential lot, freestanding lot that you want to continue to have as a freestanding lot.
I'm inclined to say yes if the landscaping plan.
I agree. It needs to be both landscaping plans, and I would recommend merging the lots, not applying for a special use permit, but I mean, however we send this to the city council is how we do, and then the city council will act on their behalf.
But if you change to C2, right, then the lots become buildable to the edge.
Yeah,
That's true. You'd be affording them more development capacity here,
especially. if
which,
they
you know,
stay separate.
I mean, given where it is that the worst thing in the world?
Right.
If there was an apartment building here?
Oh. Multifamily residential would be great, but there's other C2 uses that might not be. But I mean, look behind it too, so it's,
Agreed. Yeah, parking is very difficult. I actually looked at one of the new houses with clients and we had to park across the street on the sidewalk. Yeah, it was terrible.
yeah. I'm not against it, I just don't feel as compelled. Because it's an action of the applicant that I mean, they're coming in to try to remedy it, but they're saying that, you know, we need to keep what's here, but you installed what's in a residential zone, so.
But lot 88 could also become a house.
Could
Good.
become multifamily, it could become a business, separate. And apart from this, they could sell it off to someone else. And it could come whatever C2 allows. If the applicant's successful in the same change. Go ahead.
Quick question, I saw the letter from the state rep, did we get the ward council member? Anything from this one?
Our office has tried on multiple occasions to have a meeting with the councilwoman. And today I followed up, and it was the last time before was a couple of weeks ago. Trying to schedule something with her, and I know, you know, right now we're in the midst of re-election time. The council's on recess.
I heard something about that.
Trying to get a hold of her.
Yeah,
Yeah,
but
we've tried. We've been trying for many months to try and get a meeting with the council.
okay,
Well, if we push this forward, you will get
yes, yeah, a little uncommon to get a state rep, but not a city council member, but as far as I'm concerned, good to go.
Yep. We can entertain a motion then. I would recommend that we follow the staff report if we do send this to the city council, and that the lots be brought into conformance with the treated, both lots. And that they shall legalize the parking by merging the lots or applying. I would like to just say merging the lots, but they have the option. So as drafted in the staff report.
You want read in or just say,
Yeah, you could make that recommendation, just.
I will, based on the foregoing discussion, DPD recommend that the approval of the proposed zone change to the city council subject to the following conditions. 1, both lots shall be brought into conformance with the tree and landscaping requirements of the zoning ordinance. 2, the applicant shall legalize the parking at 25 Douglas Ave by merging lots or applying to those specially operated principal use park.
Okay, we have a motion to a second. All right, we'll go around and do a vote now.
I'll vote no.
Dave,
Aye.
Lindsay,
Aye.
Rachel,
Aye.
and I'll vote aye. Moving right along to agenda item number 5. Referral number, city council referral number 3621, abandonment of a portion of West Park Street. We have someone from the applicant here. I mean, I'm okay hearing that. We can do it based on that.
All right. Then let's do
I
that.
mean, it's pretty simple.
Okay, I'll take this one. Okay, so what we've got here is West Park Street in Smith Hill. This is a street called Calverley. And West Park Street kind of dead ends And you can see that there's a portion of it that's not built out. West of that portion, in some cases, it's known as Selwyn Way, although it still shows up as West Park Street on some maps. And the zoning, you can see east of this break is residential, and west of it is heavy industrial, M1. And what's interesting here is if we look at the terrain, the contours, you can see that there's a very steep drop between this easterly portion of West Park Street and Selwyn Way to the west. And again, the industrial zone here along Selwyn Way. The petitioner, Eric Bright, owns the several parcels that abut the section of West Park Street, either Eric, in the name of either Eric Bright or West Park LLC. So he owns all of these parcels on both sides of the street. The street comes to an end right here, and he's looking to abandon the portion of West Park Street that abuts his lots to the north and to the south of West Park Street. And his intention would be to kind of create more outdoor space and some parking areas for his properties here. I've spoken with the city engineer at the Department of Public Works, and he says that he does not object to this abandonment. It would simply make what is now a dead end a little bit shorter. And it would make the owner of these parcels responsible for the maintenance of this area of what is now a public right of way. So it's about as simple as that. The city will not develop this steep slope into anything such that there could be pass-through traffic. So this would not in any way prevent the connection of these two parts of the street. They will not be connected by the city.
That was gonna be my last question.
Yep.
Okay. Commissioners, do you have any questions for Bob about this?
Does it create a buildable, it's not a developable space?
No, it wouldn't be a developable space, but it would make, depending on how the applicant wants to reconfigure the land, it could, there is some land that is not currently developed, so it could make it bigger. It could enable perhaps more opportunities for larger scale housing. This is all zoned R4 in this area. So, you know, there is the possibility that there could be a larger apartment building, but you know, this is a pretty good place for density. You know, I could envision some kind of an apartment building at the end of this street.
Could improve the conforming lots. Yeah.
It would add land to them such that they might be more developable.
Any other questions?
It does eliminate one of the opportunities for Providence to install a funicular, which I just see something, but it's a small green. I'm going to let it go real up.
Mr. Azar, do you see any potential for a funicular in the?
That hadn't occurred to me.
Had occurred to me. We still have, I mean, there's a lot of hills in other parts of the town that.
No, I can feel about one of this. I just happen to love nuclears.
They're fun. I like them too.
This is, I support this application.
Do you want to read the staff report and then we'll see if anyone here from the public is around?
Sure, and Commissioners, going through your criteria for street abandonment. As you saw, this portion of West Park Street runs east to west from Caverly Street and terminates in a dead end. While it provides access to the lots that it abuts, it is not particularly useful beyond lots 158 and 246, as the remainder of lots on the street are owned by the petitioner. So based on that, since this portion seems only to be useful for accessing property owned by the applicant, we do not object to the proposed abandonment, as it would not have an adverse impact on the public interest. Based on that, we don't foresee any negative impact on future development or health and welfare, as this portion of the street is not essential to providing access to other parts of the city. The petitioner owns the lots abutting the abandonment area. We don't see any physical or legal access to surrounding areas being denied. And currently, it's unknown whether any public services or facilities need to be protected, provided and maintained, but the petitioner is required to grant any necessary easements. And a petition and plan have been provided, and as is custom with street abandonments, the petitioner shall apply for an administrative subdivision to merge this portion of the abandoned street with their property. So based on that, we recommend that you make a positive recommendation to the Committee on Public Works, subject to these conditions, that they apply for an administrative subdivision, which will include a survey to merge the abandoned portion of the street with their property, and that they grant any necessary easements for utility access and easement.
Okay, we will open up to public comment at this point. If anyone here in the physical room is here to speak on this agenda item, you can stand up or walk forward and we'll hear you at this time. And if you're joining us from the virtual room, please press *9 if you're calling in, or raise your virtual hand in the bottom middle portion of your screen. And seeing no one, we will close the public comment portion of this agenda item. I saw this one come through and I looked at it on the map. I'm like, oh, I know exactly where that is. That actually makes a lot of sense. I didn't see any way that the city would ever connect those two portions. It's just not physically possible without a food, which I hadn't thought of until tonight. All right, would anyone care to make a motion on this?
Make the motion based on the discussion that the commission will advise the Committee on Public Works that the proposed abandonment be approved, subject to the following conditions. 1, the petitioner shall apply for administrative subdivision and provide a survey to merge the abandoned street with their respective properties prior to appearing before the City Council. And 2, the petitioner shall grant any necessary easements for access to property, utility access, and maintenance.
We have a motion. Do we have a second?
One second.
All right, we'll go around and vote. Noel,
Aye.
Dave,
Aye.
Lindsay,
Aye.
Rachel,
Aye.
and I vote aye. Best of luck, Mr. Bruss. And on to our next agenda item. It's a minor subdivision, a public hearing for case number 26-062 UDR 25 Fairview Street. This is Unified Development Review. So why don't you get set up while the stenographer gets settled before we start on this agenda item, because we're going to want to have them hear everything that we say from this point. You just let me know when you're ready. You want? Okay. All right, go ahead, Choyan, take it away.
Sure, and commissioners, this is a request to subdivide the subject lot, which measures about 6,150 square feet into two lots of 3,525 square feet and 2,625 square feet. It is occupied by a dwelling and which will be located on the larger lot. And this subdivision was requested pursuant to section 2003D, which allows you to subdivide, which allows previously non-conforming lots which are currently merged to be unmerged back into their previous state, provided you have a minimum lot size of 3,000 square feet and a width of 30 feet. And as you will see, the smaller lot of 2,625 square feet could not meet that 3,000 square foot limit, and therefore the applicant requested an administrative modification which was objected to. And that is why they're before us seeking relief from the lot area requirement. And the applicants here, they can walk you through the application as well as the variance criteria.
This-
Good evening, Commissioners.
I'm sorry,
Al,
I'm sorry, just 1 second, Mr. Chair, if I may.
Yes, absolutely.
Just to clarify, so I don't know how many of these have actually come before you before, but I just want to make sure you understand that if both of these lots were 3,000 square feet, then they wouldn't be coming in front of this board. This number, 2625, is within 15% of 3,000 square feet. That allows the applicant to apply for administrative modification through the zoning official. That's what the applicant did. The law says if there's an objection to that granting of the administrative modification by any of the people that are entitled to notice, which would mean direct abutters, then it immediately proceeds to the zoning board for consideration as a variance request. Because this is a subdivision, you're the zoning board. So that's why this is in front of us, just to make crystal clear.
Thank you for that clarification. Now, if you'll introduce yourself, you can take it away.
Good evening, Commissioners. Corey Allard for the applicant Ayala Properties LLC.
Are you an attorney?
I'm an attorney.
Okay. Wanted to see if I need to swear you in. So,
No, I'm an attorney. So we're here seeking UDR minor subdivision approval with the dimensional variance as discussed previously. As Troyan indicated earlier, the total lot size, lot area, the existing lot, lot 64, plat 64, lot 967 is 6,150 square feet. And our hardship comes that because of because of the nature and the characteristics of the land itself.
Would never allow.
If you can see, proposed parcel number 2 is shorter in length than parcel number 1, which causes a shortfall in the with the area. Now, we can't just move the lot line over to account for that difference, because we would violate the side setback lines on the building, the structure that's situated on parcel number 1. So that's the closest we could have gotten. That's the largest area we could have gotten on parcel number 2, which again is it's short of the 3,000 square feet as required by 2003D, but it is within 15%. It would have otherwise qualified for an administrative modification.
do you have any experts to testify tonight? Because as the attorney, you can ask the questions, but you can't testify in a zoning matter.
I do not have an expert on hand tonight.
Okay.
Or even just a.
Is the client or the property owner?
I think my client's on Zoom.
We are.
Okay.
You want to?
Did that microphone just conk out? Could you speak in?
Oh, my client's on Zoom.
All right, Troy, all right.
We need to check and see if the batteries.
Let's pause for a second while we change the batteries. Are you,
Are you prepared to ask your client questions through Zoom if Their client is here to meet the standards?
I can do that.
Okay,
And who,
and who would
who's
be,
your client?
client?
Is it Andy Andujar?
Oh, raised his hand, yep.
Okay.
This chair, Andy.
Hello, Andy.
Good morning, good afternoon, commissioners.
Are you able to turn on your camera as well, or you're not prepared to do that?
Oh, yes.
All right.
I should have got dry. I was in the middle of going to an event, but all right. Oh, sorry.
We're changing mic batteries, so just give us a second with
right.
details.
Let me put a polo shirt on at least, huh?
Yeah, you're welcome to do that, yes, while we're changing the batteries. And then when you come back on, we'll have the stenographer swear you in.
Okay, I'm ready.
All right, would you care to swear him in?
Would you raise your right hand? Do you solemnly swear that testimony you're about to give shall be the truth, the whole truth, and nothing but the truth to help you God?
So I do.
Okay, and if you could just state and spell your name, please?
Andy Andujar, Andy, and last name is Andujar.
Thank you. We're still working on that microphone for your attorney, so sit tight.
Thank you.
Second.
Okay, thank you.
Okay, Mr. Andujar, what's your relationship with Ayala Properties LLC?
I am the contractor on site.
Okay, and you're familiar with the subdivision proposal?
Yes, I am.
Okay, and you've reviewed the plans that were submitted?
Yes, sir.
You reviewed the application that was submitted?
Yes, sir.
And you're familiar with this proposed land development?
Yes, I am.
Okay, and you're familiar that we're here for uniform development review with minor subdivision approval, and a dimensional variance?
Yes, sir.
Okay. And what's the total square footage on the parcel plat 64 lot 967 known as 25 Fairview Street?
I believe it's 6,150 square feet, if I'm not mistaken.
Okay, and under 2003 point D, you're familiar with that ordinance?
Yes, I am, sir.
And under 2003 point D, what's the minimum square footage for a subdivided lot?
3,000 square feet.
Okay, and would you be able to get?
Attorney, I'm just gonna interrupt you real quick. You're the attorney, so you can state the legal facts. You need to ask him about the hardships, the variances and the requests. I just don't.
I was just setting what I was getting there.
Yep, perfect. It's not a quiz to make sure he remembers all the numbers, that's all.
Thank you, Commissioner.
So, parcel 1 was proposed to be 3,525 square feet. Isn't that correct?
Yes, sir.
The parcel 2 is proposed to be 2,625 square feet. Isn't that correct?
Yes, sir.
Now, that 2,625 square feet is less than the required 3,000 square feet.
Yes.
Why is that?
Because if you look at the map, it seems like the house behind maybe at some point in time took some land off of it, and that's why the lot is not like 2 squares. So it is shorter, but it does meet the 15%. So that's why we pursued this route.
Okay. Why not just move the lot line over?
I believe we cannot do that.
Okay. What you know why you can't do that?
I think if we move the lot line, then we won't be able to have parking for the house that's going to be built on the new lot if approved.
And so it's your testimony here today that you can't move the lot line over to create additional area?
Yes, sir.
And the reason why that you can't get additional area is because of the length of the parcel number 2 is shorter than parcel number 1.
Yes, sir.
So that, decrease that, variance in area, that, 2,625 square feet is caused by the unique nature of the land.
Yes,
Like I know-
correct.
Thank you. Now you can continue on to anything else that you have, but I appreciate you jumping in and doing this without any notice, both of you, so thank you. Is there anything else, or is that your?
No, that's my presentation. I mean, the only other thing I would add is that we, even though we're here, for a UDR, minor subdivision, if this was an application 6 months ago, we wouldn't be in front of the board. It would have been approved, by staff under the old zoning ordinance, because it would have been 2,500 square feet. The new zoning ordinance was 3,000 square feet, so we need to come for relief.
Is that true, Mr. Azar? It was just changed, right?
Yeah, the ordinance formally said that you could have as little as 2,500 square feet and 25 feet of frontage. We changed that fairly recently because the state had introduced a similar process for creating small lots, and they used the threshold of 3,000 square feet and 30 feet of frontage. So we decided to go with that.
The only other thing I would like to add is that this is an R3 zone. So if the post structure on parcel 2, looking forward into the future, would be consistent with the comprehensive plan in future planning for residential use in that area.
Just real quick, what if we were not to, were to deny the request, would it be more than a mere inconvenience to the applicant, Mr. Andahar?
Yes, it would. I mean, we kind of set everything in motion. I just want to let also the commission know that in our original application, we had 4 out of the 5 positive in support of this, and it was in the, I don't know, I'm not sure if it's in this packet, but it was in the original packet. And I also spoke to Councilman Sanchez, who does not have any issues because he does want to create more housing in the area.
Okay. Then with that, commissioners, do you have any questions for the applicant? All right, let's hear the staff report.
Sure, Commissioners. So real quick, we can go through the variances we discussed. This is a polygon with asymmetrical lengths. And based on the location of the house and the requirement to meet the setback, the applicant isn't able to meet that 3,000 square foot minimum lot area, requiring the lot in question to be less than 3,000 square feet. And based on that, the shape of the lot, as well as those requirements, we do find that it results in a hardship. And they are before you seeking relief because they did ask for an administrative modification that was objected to. This particular lot lies within the medium density residential development designation of the future land use map of the comprehensive plan. The plan does note that some areas contain residential development at higher but appropriate densities. And the resultant density of the subdivision will not exceed what is permitted by the ordinance on 6,150 square feet of lot area pursuant to 2003D. And based on that, we find that the subdivision will conform to the general character of the area and not impair the intent of the comprehensive plan. And also, as we discussed, denial of the requested relief would prevent subdivision of the lot into how it was previously platted. And this would amount to more than a mere inconvenience. And based on that, we would recommend that you approve the requested relief for lot area. As far as the subdivision goes, we do find it to be consistent with the comprehensive plan. Again, given that it's located within the medium density residential designation and the lots created through the subdivision would bring the site into closer conformance with the type of development envisioned by the plan, which is detached structures on separate lots. And also we should note that objective LU3.I encourages creation of undersized lots to unmerge previously merged lots. So based on 2003D and subject to you granting relief, they will conform to the zoning ordinance. However, they are required to remove any accessory structures and excess paving depicted on the plan. They are required to apply for a zoning certificate for compliance to document all those changes. We also should know that the plan indicates a significant tree in the vicinity of parcel 2, and per the ordinance, the applicant is not allowed to disturb that tree. We don't foresee a negative environmental impact. This will be a buildable lot and we don't foresee any constraints to development. And adequate street access will be provided from Fairview Street. The applicant is required to install the curb cut, providing access to parcel 1 as depicted on the plan. So based on that, we would recommend that you approve the subdivision subject to these conditions. The applicant shall obtain a zoning certificate for compliance documenting removal of accessory structures and excess paving, and that they install a curb cut to provide access to parcel 1 as depicted on the plan.
Okay. Turn my mic on. Okay, this is a public hearing. So at this point, we will open we'll ask the applicant's representative to sit down for a minute while we open up public comment. If you're here to speak on this matter, please stand up and make your way forward. And if you're joining us from the virtual world and you wish to speak on this matter, please raise your virtual hand or press *9 if you're calling in. Go ahead and have a seat at the table, and when you do talk, make sure to talk directly into the microphone. And I'm going to have the stenographer, swear you in. You're going to have to introduce yourself and then swear yourself in.
Yeah. No, maybe it's but who knows.
Commissioner, just want to let you know that we received letters from Candace Polanco and Richard Morelli. And yeah, we'd just like to acknowledge you sent her.
Which is also a part of the record, and everyone's received that in advance of this meeting. So now,
If you could just please raise your right hand. You will sign and say that testimony you're about to give the truth, the whole truth, and nothing but the truth and nothing but the truth. And if you could just state one more time, and then spell your last name. Candace Polanco, P-O-L-A-N-C-O.
okay, Ms. Blanco, we have received your letter as stated, so you don't have to reiterate that verbatim, but you can just.
My concern is that the lot, it's right enhanced to my property where the parking is, okay? The construction, when it was even going on, was right into my bedroom. Hear everything going on. That's gonna impede, and it's only gonna be valuing my property. If they build a house there, I'm not gonna have no privacy. I have none whatsoever. I've been there for 30 years in that community. And it's just gonna be it's gonna force me to sell my house, because I'm not gonna have that peace and enjoyment that I have for all the years I've been.
All right, is that your testimony today?
Yeah.
All right, thank you very much for your time. Thanks for coming in. And again, we have your letter as well. Is there anyone else here in the physical room who wishes to speak on this matter, or in the virtual room? Again, if you're joining us virtually, please raise your virtual hand in the bottom middle portion of your screen, or press *9 if you are calling in. And seeing none, we will close the public comment portion of this agenda item. All right, commissioners. I did receive the neighbor's letter beforehand. do emphasize. But. It's a pretty straightforward subdivision, if not for the change in law and if not for the irregular lot size, they'd be able to divide it equally and create 3,000 square foot lots. The hardship is due to the unique characteristic of the land, which is the irregular shape of the lots. I would rather have this subdivision than a legally conforming one with 3,000 and 3,000, because that would create a lot that's just a strange size. So that's my thoughts. I don't know how everyone else is feeling about this one. Again, it's a 15%, under 15% change.
If you're looking at this property, it appears that the house behind it on Dover Street, at the lot in question that's undersized, the lot behind it on Dover Street seemed to be the parcel that encroached on this parcel, giving it less than the 3,000. But the width of the parcel seems to be consistent with every other, predominantly most of them on that street. So while I am also sympathetic that this seems to be right adjacent to our house, that seems to be consistent with the proximity of most of the other homes on that street.
Yeah, it would be in keeping with the general characteristic of the neighborhood, yeah, for sure, which is the second standard that we had to meet, and the third is a more than mere inconvenience if we deny.
Did we require privacy fence in order to grant the variance, just to create separation that the buyer might be looking for?
You're allowed to put conditions of approval.
That would be more on the plan, right? The subdivision, not necessarily the dimensional relief.
Well, yeah, I mean, that, yes, that's a, I'm not sure.
Just mechanically.
Yeah. I think it could be a condition of the zoning grant or of the subdivision, that either one. Yeah, along the westerly property line.
The tree was my only other real concern. Could we have a condition where the city forester has to? It's one thing not to chop it down, but it has to have a certain distance that heavy mechanics aren't driving the root structure.
Yeah. Yeah, so with respect to the tree, what is shown on the plan is a 48-inch tree cluster. Honestly, I'm not sure how the city forester would interpret that. If it's got multiple trunks, if the forester would consider that to be a significant tree that needs to be protected. But certainly, any approval that you grant for this subdivision could be contingent on the city forester's opinion as to whether it's significant, and if it is significant, that any development include a tree protection zone such that the tree is not compromised during construction.
Right, so if they do deem it significant, then they would dictate what the proper process is.
That's right. Yeah.
That would be the condition.
Yeah. Yeah.
And we'd add that, like, again, that would probably be on the subdivision.
Sure.
That's why I would recommend putting that in the subdivision.
Both of them.
Yeah.
The first could go in either. I think it makes sense to put it in the subdivision.
I think
Or
if you're
either.
gonna put conditions, you could put them both on
On the subdivision.
Yeah.
I think everything could go on the subdivision with conditions. Do you agree, Attorney DeSanto?
I would have said very.
Yeah, I think both approval processes allow the imposition of special conditions. I do kind of think that the privacy fence is aligned with the zoning relief.
I agree with that one.
If
More
it
so.
were something the board were inclined to.
I'm okay with the fence on the zoning, if we were so inclined.
They have the setbacks are reduced because of the size of the lot. Is that correct? The 3 foot.
Proportion.
Yeah, not for the subdivision itself, but should you approve the subdivision, then there would be the proportional reduction of setbacks for the new lot.
So in the plan, it shows a side setback of 3 feet from the two, I think.
Yeah, I think
To build 2 lots.
that's about right. Yeah,
And so the design of that building would be a fireproof wall.
well, if they build right up to that line,
Or even 2 feet away. 5 foot, I think is the size.
I think you can be within. I mean, you can sort of have jogs. You could have a wall without penetrations closer than 5 feet, but as you get, I think as you get between 3 and 5 feet, you can start to have some penetrations, and if you include some indents to get to that 5 feet, you could have.
I was just thinking about it from the privacy standpoint.
Yeah.
If we impose, or if we propose a fence, it also reduces the spaces quite a bit.
Yeah.
For working maintenance and all that. And so I would be more inclined to look at the privacy issue from the design of the new. I don't know how we could do that, but the design of the new building.
We can condition fence. We can't condition the design.
Well, we condition.
Could you condition a deeper setback from the side?
Well, that's state law, isn't it? It's proportionally.
Yeah, once the lot is created,
Size.
they're entitled to that. Now, we do have design standards, however, that are
They would have. to
that are new. So this is a
R3.
R3. Let's see. Okay, so what we say in the for single, 2, and 3 family houses is that there needs to be a minimum of 15% transparency on each facade. Those are facade we define as what faces a street. On other building faces, this is new language, there shall be a minimum of 10% transparency or the maximum allowed by the building code, whichever is less. Transparency is calculated on the basis of the entire area of each building face. So I think what that means is 10% or the maximum allowed by the building code, whichever is less. At 3 feet.
At 3 feet, it might be 0.
Is it? I don't know the building code well enough to
Right,
make that
because if you're that
determination.
close to the property line, you may not be able to have an
3 feet,
opening.
You
You can't have an opening, so you can't have, so the building code is 0.
Yeah,
To make a fence redundant.
Well, and also it would eliminate.
If
the
they
use of
build
space.
to that build to zone, they don't have to build to that setback, that's just the setbacks.
The whole thing is pretty ugly. Practical matter,
Right,
like they say.
yeah,
So I just am feeling that requiring a fence, so if you have 3 feet. On either side, because you only have 5 feet on the other side, that's 6 feet.
but we can't require them to build to the build to zone either.
No, that's right. I just feel that requiring a fence, in my opinion. If they don't have a way to take it down later.
How about requiring a fence or how would we
I
say
mean, I
that?
get the privacy report need, the need for the privacy.
Or a face without. But if we require a face without
If they
any,
build a 2-story building.
You don't
it'll be
want
above
yeah, we don't want that.
you don't.
You can't do it.
Yeah. Get into the weeds with.
I think we require a fence now, and then they can come back if they have something else. Somewhere. That's what I would suggest. But in that case, we don't put it with the variance, we put it with the plan. Because to come back for zoning, you need a zoning relief instead of a modification to an approved plan. Right?
Yeah, okay.
That's my gut.
Yeah,
And
Yeah.
fence is a 6 foot privacy, it's not.
Right. Yeah, and if there's a compelling reason to not have that, I'd rather send them back here than send them to the zoning board for relief on their variance that we conditioned.
right, because it's really gonna depend on good planning and
Exactly.
design.
And then we'll have the ability to modify that if needed in the future, if they came back for a modification of the approved plan. So that changes my opinion to move it to the plan. 4 would be privacy fence. If we move this forward. Any other thoughts along this application? Because I like the idea of having something in there to safeguard. But I don't want to make it like overly burdensome if this applicant is gonna put in a wall that's a fireproof wall within 3 feet of the property line, they're not gonna have any need for that. So,
Right, I mean,
correct. And they may be great neighbors and put up a whole bunch of landscaping and do all kinds of stuff to make it their neighbor happy. Who knows? This will give us the ability to
can provide a letter some relief during construction. process.
some, yes, actually, and you could state that. Yeah.
From a construction perspective, it's very hard to state, put this fence in and then.
Yeah, because the sequencing of that, you might not be able to, the constructability of it may diminish while you're. There are hours of operation and there's dust control, there's certain things that can be
In
monitored.
theory, the construction should be mindful of the property boundaries no matter what.
Should,
Probably would have some type of fence just while there's foundation digging and that type of thing in the first place, but.
mostly it's construction.
Maybe at least.
Those are few and far between.
Yeah. Okay. Any other thoughts on this application? Well, if we were going to start with anything here, it would be action on the dimensional relief. Based on our discussion, the applicant's discussion, and the findings that the 3 findings that were testified to by the applicant and our discussion that ensued thereafter. We would, based on the foregoing discussion, approve the requested relief. Do we have a second? Okay, we'll go around and do a vote. Noel? Dave? Lindsay? Rachel? And I vote aye. Now, moving on to the preliminary plan. If someone were to put a motion forward, it could be that we approve the minor subdivision based on the analysis and findings contained in the report and the discussion that ensued surrounding the dimensional variance and this planning application. Pursuant to dimensional relief, we already did that. Subject to the following conditions. That number 1, the applicant shall obtain ZCFC documenting removal of the accessory structures and excess paving on parcel 2 prior to submitting for final plan approval. Number 2, the applicant shall install a curb cut to provide access to parcel 1 as depicted on the plan prior to final plan approval. Number 3, prior to final plan approval, the applicant shall meet with the city forester to discuss the possible significant tree, and if it is a significant tree, include a tree protection zone and plan with the city forester's approval. Number 4, the applicant shall install a privacy fence on the western property line, 6-foot tall stockade fence. That's it. I think I got everything.
talking as a style, is it, can we just say privacy?
Opaque,
Opaque.
opaque.
Opaque. Solid opaque fence. How about that? We'll change it from stockade to solid opaque fence. All right, so someone could say so moved or could have their own motion put forward.
So moved.
Okay, do we have a second?
A second.
All right, we'll go around and vote. Noel?
Aye.
Dave?
Aye.
Lindsay?
Aye.
Rachel?
Aye.
And I vote aye. Best of luck. Best of luck. And I believe that may be the last item on the agenda. So I would entertain a motion to adjourn.
Motion adjourned.
Do we have a second?
Second.
Thank you. See you next month.
Thank you.